Good morning, everyone. It's a pleasure to welcome everyone here to the sixth meeting of the Public Utility Commission for calendar year 2014, and ask that you join us in the Pledge of Allegiance.
Pledge of allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The first item on this morning's agenda is the approval of the minutes from the February 20th meeting, and I'd like to recognize Commissioner Cawley as editor of the minutes. Commissioner Cawley.
Thank you, Chairman. I have reviewed the minutes of our February 20th public meeting, and I move that they be approved as submitted.
Second. Any discussion? Any objections? Hearing none, the minutes are approved as submitted. It's a pleasure to welcome to the podium to begin our public meeting Ms. Cheryl Walker Davis, and she's happy, I'm happy, and we're going to start public meeting here.
Yes, congratulations on your confirmation, Mr. Chairman.
Thank you, Cheryl, and thank you, everybody. I want to recognize our bureau directors, and also want to thank my colleagues for the moral support that they provided me through the grueling process, and also want to recognize June Perry. June doesn't often get recognized for her good deeds, but getting me through confirmation is a huge good deed, and I want to recognize her and Tom Bean for their support as well. It's been a tremendous honor to work with this, as Mike McCarthy reminded me, this august body of commissioners, and they're great people, and we might disagree on issues, but we also have a lot of agreement, and you know what we agree on? We agree on the fact that we have great professional staff here. It makes this job very enjoyable. Although I'd like to not have more hearings on variable rates, but that does come with the combat pay. And Cheryl, with that, I'm going to recognize you to formally begin public meeting here.
Thank you, Mr. Chairman. Good morning, and good morning, Commissioners.
Good morning.
Good morning.
May it please the Commission, on behalf of your various offices and bureaus, we present for your consideration and disposition the following agenda items, commencing this morning with matters on behalf of the Bureau of Audits. On page 1 of the public meeting agenda, it is recommended that the Commission adopt the recommendations to release the various audit reports relating to UGI Utilities, Inc., Electric Division, as well as PPL Electric Utilities Corporation.
So moved. Second. Any discussion? Any objections? Hearing none, the motion passes unanimously.
On page 2 of the public meeting agenda, with regard to the proceeding involving Columbia Water's petition requesting a hearing to allocate costs associated with the bridge replacement in Lancaster County, there is the joint motion, Mr. Chairman, that you have with Commissioner Brown.
Yes, before the commission here are the exceptions to the recommended decision filed by Columbia Water Company. The recommended decision denied Columbia's request to be reimbursed for certain costs incurred related to a bridge replacement project. It is well settled that when apportioning cost in rail highway crossing cases, the Commission is not limited to any fixed rule, but takes all relevant factors into consideration. We certainly have in this case. The Commission has articulated 4 factors as a guide in allocating relocation costs of non-carrier public utilities in the Wilkes-Barre area. These factors are: 1, the benefit received by the ratepayers of the particular utility; 2nd, the availability of state or federal funding for the projects; 3rd, the placing of cost upon the parties responsible for the situation; and then finally, the equities of particular situations. Now, on October 17th of 2013, the presiding administrative law judge initiated a recommended decision in this matter, wherein he analyzed the 4 factors articulated in this Wilkes-Barre case. In doing so, the ALJ concluded that Columbia did not carry its burden of proof and denied Columbia's request for reimbursement. We do not disagree with the ALJ's conclusion that the 2nd and 3rd Wilkes-Barre factors suggest that Columbia should bear the cost of relocating its facilities because of the Montville Bridge project. However, Commissioner Brown and I believe that the 1st and 4th factors require that at least some of the bridge replacement costs be allocated to the Pennsylvania Department of Transportation. When considering these factors, particularly the equities of the situation, it cannot be overlooked that the 2011 main replacement occurred only 5 years after Columbia's prior main replacement. Considering water mains such as these should last at least 100 years, replacing one so quickly is undoubtedly a waste of resources and possibly could have been avoided through better coordination between PennDOT and the utility. Regarding the equities of the situation, in its petition, Columbia argues that it had been aware that PennDOT planned to reconstruct the bridge a few years later. Regarding the equities of the situation in its petition, Columbia argues that it had been aware that PennDOT planned to reconstruct the bridge a few years later. It probably would have coordinated the main replacement with PennDOT's crossing project. We often talk about this with disc-related projects as well. We agree that there was a communication breakdown between the two parties in this case, and had each of them been more proactive and conducted reasonable due diligence, the redundancy of constructing the two water mains within such a short time period could have been avoided. For these reasons, we believe it is unreasonable for Columbia to bear 100% of the cost associated with both mains. Instead, a reasonable outcome would be for both parties to share equally the cost of replacing the first main, since that it is a project that could potentially have been avoided. However, because the cost of the 2005 water main is not at issue here, we direct that 25% of the approximately $160,000 cost for the second main replacement be allocated to PennDOT, with the remainder allocated to Columbia. Additionally, we encourage PennDOT and all the Commonwealth's utilities to be more proactive in communicating with one another in situations such as this one. With the passage of the recent transportation bill, there will be many PennDOT-initiated construction projects throughout the Commonwealth, many of which will necessitate the relocation of utility lines and mains. We encourage PennDOT and all of our utilities to use this case as a learning experience and improve outreach and communication on such projects going forward so that customers are not subjected to the inconveniences and costs of replacing facilities twice. Therefore, this morning we move that, one, the recommended decision be reversed in part, and that the exceptions filed by Columbia Water Company be granted in part. And finally, that the Office of Special Assistants prepare an opinion in order consistent with this motion.
Second.
Any further discussion? Any objections? Hearing none, the joint motion passes unanimously.
In omnibus fashion, it is recommended that the Commission adopt the recommendations proposed by the Office of Special Assistants appearing on pages 3 and 4 through and including the recommendation in the complaint proceeding involving Adeyemi Oyeyemi versus the Philadelphia Gas Works.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
At the top of page 5, we recommend the adoption of the staff recommendation in the proceeding involving the petition of Pike County Light and Power Company for approval of its default service implementation plan, noting the statement of Commissioner Brown.
So moved.
Second.
I'd like to recognize Commissioner Brown for purposes of her statement. Commissioner Brown.
Thank you, Mr. Chairman. Before the Pennsylvania Public Utility Commission for consideration and disposition is Pike County Light and Power's petition for approval of its default service implementation plan. Similar to Pike's 2012-2014 plan, the proposed 2014-2016 plan provides that 100% of Pike's default service supply will be procured from the New York Independent System Operator spot market. The OCA has challenged the proposed plan, arguing that permitting the purchase of default service generation through the spot market only is in violation of the prudent mix standard provided for in Act 129 of 2008. The Competition Act originally required default service suppliers to acquire electric energy at prevailing market prices. One of the precipitating or triggering factors for changing the prevailing market prices standard was the belief that wholesale market pricing was volatile and that too much emphasis was on short-term procurement in order to satisfy the prevailing market price requirement would expose customers to the fluctuations that commodity markets sometimes exhibit. In 2008, the General Assembly put in place measures to mitigate the effect that these fluctuations have on consumers by enacting Act 129, which among other things modified Section 2007 CE3 of the Code by eliminating the prevailing market price standard. Under Act 129, electric generation procured for service defaults to serve default service customers' loads shall include a prudent mix of the following: spot market purchases, short-term contracts, and long-term purchase contracts. I know that the Commonwealth Court has since ruled that this commission acted within its bounds of Act 129 when the commission approved Pike's 100% spot market procurement in its last default service filing, and that was the Popowski versus Pennsylvania Public Utility case. However, the court in Popowski also found that the commission's approval of a spot market only procurement in light of the prudent mix standard was lawful since the commission properly considered the possibility of including short-term contracts, including financial hedges, and determined it was not prudent to do so. The record does not reflect that the same consideration was given in the extension under the current plan. As acknowledged by the courts in Popowski, the preamble to Act 129 indicates that price stability was one of the goals to be achieved by that act, and that price instability was one of the harms the act was intended to ameliorate. The court ultimately determined that the commission had not discounted the importance of price stability, and that the commission concluded that the additional benefits of a financial hedge would not be justified by the additional cost. Although I have the legislative background and direct working knowledge in the drafting of Act 129, and as an officer of the court, I know that my legal background requires me to give deference and respect to the court's holding and the possibility of unintended consequences of the passage of Act 129. There has been no further legislative measure enacted to amend this section. Therefore, in this case, and in the court's 2012 order, it remains the law of the land. And following the court's decision, I note that the court's ruling emphasized the exercise of balance and discretion by the commission. As such, I take my cue in reviewing this matter from the court. Significant spot market price spikes have taken place in the wholesale commodity market since the commission issued its decision in 2012 to approve Pike's spot-only procurement strategy. At that time, commodity prices had been gradually decreasing. The market today has changed, as markets tend to do. Review of the record in this case reveals that Pike's default customers have experienced volatility in the rates charged during the past few years. Prices for Pike's default generation range from 2.4 cents per kilowatt hour to 11.78 cents per kilowatt hour for any given quarter since 2010. These commodity prices translated into default retail prices that fluctuated up by as much as 59% or down by as much as 69% from one quarter to the next. Given the recent price volatility experienced in the wholesale energy markets, it is important that in exercising its discretion, the commission not ignore the price fluctuations experienced by Pike's default service customers in recent years. It is also important that the commission not ignore the wholesale energy prices spiked to extraordinary levels in January 2014. Pike's default service customers had no short or long-term hedges to soften the effect of these January 2014 price spikes. I believe that the commission should have taken an in-depth look at what hedges may be available to Pike and the cost of those hedges as compared to the effect that unhedged spot market prices will have on Pike's default service customers. There are times when the risk premium embedded in the cost of a hedge is in the public interest. The record developed in this case failed to specify what the cost of such a hedge could be. I am reluctant to support Pike's petition without this information, as it is part of the balance and discretion which I think the court spoke to in the Commonwealth Court decision. I am unable to give my full due diligence in this matter without this additional information. Therefore, I respectfully dissent approving Pike's default service plan.
Any further discussion?
Yes, Chairman.
Commissioner Cawley.
With apologies to my colleagues that they've not had the benefit of what I'm about to say because I have been on vacation, I'm going to join in Commissioner Brown's dissent, and let me explain why. The Office of Consumer Advocate objected to this plan because of its over-reliance on spot market prices. knowing full well that the Commonwealth Court had struck down the consumer advocate's challenge to the company's last default service implementation plan and our approval of it, where we approved that plan when it relied solely on market prices, where the consumer advocate alleged that Act 129 requires a prudent mix of resources and reliance on just spot market was not the portfolio approach enacted by Act 129. Same claim is being made here, that there's an over-reliance on spot prices, and that there should be a prudent mix, and we can't approve a plan based only on spot prices. Commissioner Brown's point is that the Commonwealth Court deferred to our earlier decision and disagreed with OCA because in the earlier case, we had before us sufficient information in the record as to the cost of spot market hedges. And in this case, we do not have that same evidence of record. Even though OCA challenged this petition, they did not place in the record, nor did the company's petition have in the record, any evidence of what a hedge would cost. Now, I'm fully aware that nobody can predict what future prices are going to be, but I think that the company could talk with the traders who deal in these hedges and could determine what the premiums are on an odd lot hedge, an odd lot being anything less than 50 megawatts. I therefore think that we have an obligation on our own to determine these costs if we expect the Commonwealth Court to defer to our discretion in approving a plan that relies heavily on spot market prices. And therefore, if we had the time, which I'm afraid we do not, to remand this matter for a determination of what an odd lot hedge would cost, that would be ideal. Unfortunately, I don't think we have that time, but I think it is at least incumbent on us to encourage the company to come forth with some indication that it looked at what the premiums would be on an odd lot hedge, and it rejected the cost. And therefore, we should do as we did in the last case. We could go ahead and say that the cost was too great, and it just compared to the risk of volatility. We just don't think that it's in the public interest to approve those kinds of costs. Here, we don't have enough evidence of record, and that's where Commissioner Brown, I think, is right. I therefore encourage at least the company to inform us whether they looked into the costs and what the premiums were on an odd lot hedge, and to file a petition for reconsideration so that we could modify this program for at least part of the first year and certainly for the entirety of the second year. So again, my apologies to my colleagues. I did not appreciate the facts of this case until I came back late last evening. But for the reasons I've stated, I respectfully dissent as well.
So noted. Any further discussion? We'll note the objections of Commissioner Brown and Commissioner Cawley. The motion passes 3-2, and we'll also note the statement of Commissioner Brown and the oral statement of Commissioner Cawley.
And Mr. Chairman, we would note that with regard to any written motion or statement, that those should be reflected in the record as if fully read when they are summarized. Continuing with the presentation of agenda items in omnibus fashion, it is recommended that the Commission adopt the staff recommendations, the remaining two appearing on page 5, involving the proceedings of Cheryl Zack versus Verizon PA LLC, as well as the Verizon PA and Peerless Networks interconnection agreement. And the omnibus continues with the items on page 6 through and including the recommendation pertaining to the interconnection agreement of the United Telephone, TA CenturyLink, and TCG.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On behalf of the Bureau of Technical Utility Services, it is recommended, again in omnibus fashion, that the Commission adopt all of the recommendations appearing on page 7, commencing with the recommendation of the application proceeding involving South Jersey Energy Company's request to amend its natural gas supplier license, and continuing, as I said, with the items on pages 7, 8, 9, and 10 through and including the recommendation in the proceeding involving NRG Energy Center Harrisburg's steam cost rate supplement.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On page 11 of the public meeting agenda, we do recommend the adoption of the staff recommendation in the proceeding involving the security certificate filed by the York Water Company, noting the statement of Commissioner Brown.
So moved.
Second.
I'd like to recognize Commissioner Brown for purposes of a statement. Commissioner Brown.
Thank you, Mr. Chairman. I just wanted to take the opportunity to commend York Water Company for taking the initiative to refinance a portion of their debt. I think the savings of $2 million would be very helpful to not only the company, but also to their ratepayers.
Thank you, Commissioner Brown. Any further discussion? Any objections? Hearing none, the motion passes unanimously.
And on behalf of the Bureau of Technical Services, we recommend the adoption of the staff recommendation pertaining to the Mahanoy and Mahantangle Telephone Company.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
Turning now to matters presented on behalf of the Law Bureau, commencing on page 12 of the public meeting agenda, we recommend the adoption of the item on page 12 with regard to the recommendation involving energy efficiency conservation programs and EDC plans, as well as the recommendations appearing on page 13 and 14 through and including the rulemaking pertaining to the electronic access to pre-served testimony.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
With regard to matters presented on behalf of the Office of Administrative Law Judge, we recommend the adoption of the initial recommended decision of ALJ Cheshkish in the proceeding involving Baylor, Jerome P. Baylor, TA Action Enterprises, General.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
And we recommend the adoption of the initial decision of ALJ Salapa in the complaint proceeding involving Shymar McBride versus UGI Utilities, Inc. Gas Division, noting, Mr. Chairman, the statement of Vice Chairman Coleman as well as the joint statement of Commissioner Cawley and Brown.
So moved.
Second.
I'd like to recognize Vice Chairman Coleman for purposes of his statement. Vice Chairman Coleman.
Thank you, Mr. Chairman. I would ask that my statement be entered into the record as though I had read it in its entirety. Before us this morning is the second complaint from the same customer on what I believe is the same issue. The first complaint was dismissed by the Commission back in September of 2013, and I do not see any new or novel arguments being raised, and therefore I agree with the decision to dismiss the second complaint as well. Thank you.
Thank you, Vice Chairman. Now I'd like to recognize Commissioner Brown with Commissioner Cawley for a joint statement. And I'd like to recognize Commissioner Cawley, you're going to be reading the statement.
Thank you, Chairman. I ask that it be placed in the record as if I had read all of it. Commissioner Brown and I respectfully disagree for these reasons. This is a legal issue. Fine points of the application of legal doctrines called res judicata and collateral estoppel. These are doctrines from the common law designed to preclude a litigant from relitigating a matter that has already been relitigated. Res judicata applies where the claim is the same in both instances, where a litigant has had a full opportunity and the matter has in fact been litigated to a final decision. Collateral estoppel applies where the issue is identical and the party has had an opportunity to litigate the matter fully the first time. Why do we believe that as the company moved, in this case, obtaining dismissal, why do we believe these doctrines are inapplicable? We don't believe that they apply because in the first instance, the first complaint involved the issue, and well, the claim was is that he had his meter removed and his service terminated based on an arrearage owed by someone else, a prior person who lived at that residence. He did not show up for the hearing. The matter was dismissed with prejudice. We don't take issue with that. The important point is that the claim and the issue in that case is different from the complaint that he later filed. The second complaint involved a claim that he was being denied service because of an arrearage at his mother's residence, which was a different address. So we believe the issue and the claim the second time around was different. The two cases are completely different. And therefore, the doctrines that preclude him from filing the second complaint simply do not apply. And we also feel that since this was a pro se claimant, that he deserves more of an opportunity to make his case, and that these legal niceties should not be applied so strictly in this instance. So for that reason, we respectfully dissent.
So noted. Any further discussion? Hearing none, the motion passes 3-2, noting the statement of Vice Chairman Coleman and the dissenting statement of Commissioners Cawley and Brown.
Mr. Chairman and Commissioners, that does conclude the presentation of regular agenda items. Turning now to the carrying agenda. It is recommended on behalf of the Office of Special Assistance that the Commission adopt the recommendations in the proceedings involving the complaint of Michael Prendergast versus PGW, as well as the letter notification of Trans-Allegheny Interstate Line TA Trail Co. appearing on page 1 of the carrying agenda.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
And on page 2 of the carrying agenda, we recommend the adoptions on behalf of the Bureau of Technical Utility Services in the proceedings involving the joint letter of notification of West Penn Power, Trail Co. and Penelec, as well as the proceeding involving the tariff supplement of Citizens Electric Company of Lewisburg, as well as Wellsboro Electric Company.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously. Cheryl, I don't believe we have any other items to come before public comment.
No, Mr. Chairman, that concludes the presentation of agenda items.
On that note, we are adjourned. Thank you.